Good morning, Central Florida, and welcome to the DeWitt Law Review. I am attorney Mo DeWitt, joining you every Sunday morning at 10 a.m. right here on 107.3 FM and AM 580 WDBO. Remember, the answers and advice given on this show do not constitute legal advice, but we are here to answer your legal questions. If you'd like to join the show, give us a call at 407-536-6737, or you can email us your questions at ask@dewittlaw.com. This morning, we do have a very special guest joining us, and that is Mr. Jacob Stuart. Jake, thanks for being here.
You bet, Moses. It's my honor to be here with you and your viewers.
So I brought Jake in. Jake's a very well-known criminal defense attorney in town, and I wanted him to join us because there's been a pretty prominent legal story in the news that deals with criminal defense, and that was the arrest of an individual in the murder of Tupac Shakur, which occurred, 23 years ago, I think it was?
It was back in 96.
Yeah, so there's now been an arrest made in that case.
Right.
And so, one of the interesting things about this case was it sounds like some of the defendant's own admissions led to his arrest here. I guess maybe could you start by telling us kind of a little bit about the murder that took place for people out there who may not know about it?
Yeah, it's a great thing. So first of all, again, thank you for having me on your show.
Oh, thanks for being here.
Moses, I've known you for quite some time. I think we may have met around 1996 or 97 if I think back to it.
You're actually correct, yeah.
So with this, I remember this story about what happened to Tupac in Vegas back then because it was one of the first high-profile cases that there was a murder about outside of O.J. Simpson, right, back in our era. And this is pre-Facebook, pre-social media. So Tupac, and this is in this new era of hip-hop, was at a Mike Tyson fight out in Vegas.
That's right.
And he, according to sources and things like that, had been involved in a gang, the Bloods. And there had been another competing game, the Crips. And these two gangs, as gangs do from the time of Shakespeare to 1996, 97, they fight. And they were at a Mike Tyson fight, and there had been some type of argument. And according to different sources, Tupac and the person he was with jumped these guys. They then decide, okay, we're going to come back, we're going to go get a gun, and we're going to shoot Tupac. And they did. They actually pulled up when he was leaving MGM Grand, the hotel, and actually shot him. What's interesting about a variety of things about this case is there were no witnesses. And actually, Tupac, when he was being held by the officers, when asked, his last words were actually, when asked by the officer, who shot you, his actual word was, if you, I'm not going to obviously use that. But it's interesting is that there was no witnesses, and according to the street code, even the person who was in the vehicle with him, who was the head of the record company that Tupac was with, refused to acknowledge anyone who was involved in the case. So,
and I think the police see that a lot when there's kind of gangs involved. They're protecting each other. They don't really want the police involved. Is that correct? Especially
in these gangs at the time in L.A. and Los Angeles, even though they were in Las Vegas, these were L.A.-based gangs and Southern California gangs. These were some of the most prolific in the drug trade during that time.
Okay.
And so they had money. I mean, obviously going to a Mike Tyson fight and gambling, it's
expensive.
It's high roller stuff, right? That's not your typical stuff like of a sixth grader selling, whatever. So this was a real situation, and it captivated America because Tupac was on the rise. He was a one-of-a-kind artist,
right? A
poet, some would say. And he died tragically, and we never, and he died 3 or 4 days later, succumbing to the wounds. And they never found out. And this involved jurisdictional investigations, not only from Las Vegas and Nevada, but obviously carrying over to Los Angeles and Southern California. So fast forward to 2008, and there's this, I just want to make sure I get his name right for our listeners. There's someone by the name of Dwayne Keefe D. Davis. Now, Mr. Davis is important because he allegedly was in the car that shot Tupac.
Right. He was in the vehicle, but he's not alleged to actually have pulled the trigger, correct?
Right. And so depending on who you believe, he said he was the head of the Crips at the time, back when this happened. And he was being investigated for drug trafficking, and he was given what's called a proffer. Now, a proffer for your listeners means it's a discovery tool for government entities. So if the government's trying to investigate a criminal enterprise or have someone discuss or trying to learn something without a subpoena, they will agree to allow someone to come in and speak to them, and everything they say cannot be used again in the investigation. Now, every state's a little different. Like you mentioned before, I'm not licensed in California or Nevada.
Right.
But I've done proffers at a federal level, a state level, a county and city level. Most agencies are open to do it if they think it'll help them in the overall investigation.
And so is that usually when they use it, is it's an investigative tool to get information for them?
Right. It is. And it's a way for them if they don't think they can get it any other way, like through a subpoena or through a case like this that appears to be a dead case or a cold case in that sense, that they're having a stalemate of trying to get discovery or any type of evidence to use against someone, they'll use it.
So is it kind of like a last resort for?
Yeah, sometimes, or it really depends. I mean, sometimes if they're going after a bigger fish,
Gotcha.
they'll use
That
it for
makes
that.
sense.
They'll use that as well. Like in RICO cases, white collar crime cases, they're used a lot. You'll see a lot, not to get political, but in a lot of these cases involving Donald Trump now, there are proffers all over the place.
Gotcha. And that gives the person who's making the proffer immunity typically.
Sometimes. That's what's interesting. So Mr. Davis was being investigated for drug trafficking. He then, during this investigation, actually then in the proffer, confesses to being the person who gave the order to kill Tupac Shakur.
So was the proffer related to the murder of Tupac Shakur, or was it related to drug trafficking?
It was related to drug trafficking.
Okay.
And he started talking about this. Say, hey, while I'm talking to you, almost boastfully, let me tell you what a big deal it was. Because this guy, Mr. Davis, has a reputation. In preparation for our meeting today and to share with your viewers, if you go on YouTube, you actually can go see in a Netflix series that came out in 2018, which shared this proffer to the world for the first time, that he actually said it. And so to kind of back up, so he does this proffer, right, back in 2008. He thinks at the time it gives him total and complete immunity. Now, what our listeners have to understand, our viewers, if you're watching this on YouTube or whatever, the DeWitt Law app, whatever,
YouTube, Facebook, all that fun stuff.
Right. A proffer gives you immunity if it's orchestrated, negotiated in a certain way during that interview.
Okay.
It's not like once I say it, like, Michael Scott from The Office, I declare bankruptcy. It doesn't work like that.
Right.
It gives you within the four corners or within the confines of that interview. He then fast forward. Mr. Davis, a public records request is done, part of this documentary about the death and what some believe to be conspiracy of Tupac's death. They find through a public records request this proffer interview. They then go find Mr. Davis and say, hey, can we do an interview about this? We would love to talk to you about it. He then, in this interview, back in 2018, it came out. I think the first interview was 2016, gives a full description and a blow-by-blow of exactly what happened. And it's incredible. And he then proceeds then not only to do that, to then write a memoir, because he got out of prison for drug trafficking.
Okay.
He then, from what all sources lead to, he wanted to make some money.
Right, so he writes a book.
Writes a book, goes on a speaking tour, and fast forward now, a grand jury is convened back. And to kind of give you an idea, a grand jury can be used as another discovery tool. So sometimes in high-profile cases or cases that are a unique fact pattern or cold cases or political cases, grand juries can be used. And what that is, it's a place where there's no judge, there's no defense, it's done in complete secrecy, and it's the state presenting a case to a group of select people. And these people can be convened for a week, a month, 3 months, 6 months, depends on the jurisdiction and the agency, right?
Right.
They then went and actually searched Mr. Davis's house and his wife's house back out in Nevada. Now he lives, fast forward, we're now in the summer of 2023. And they searched it earlier this year. They searched tablets, cell phones, things like that. We don't know what happened. But a grand jury then, based upon the evidence that was found, came back to essentially charge him with murder, with enhancing offenses, because it's gang related.
Gotcha. So, I mean, to back up a little bit, I mean, how would he think that he has absolute immunity in this case? I mean, because it's pretty brazen to write a book about murdering somebody.
Murder is across state lines universally. Remember, each state's different.
Right, of course.
Murder is usually the only crime that never has a statute of limitations.
Right. So I guess that's the other question.
Right.
It's been 23 years. Like you said, most crimes have statute of limitations,
Right.
except for murder. But in most cases, murder doesn't have a statute of limitation. I guess that's why, we see more of the cold cases involving murder, because they can find the killer 30, 40 years later and still, if they're alive, prosecute them.
I think this is a good example that having a great attorney like the DeWitt Law Firm really matters.
Or at your office. That's why I bring you on here.
But in all seriousness, this is an example of how powerful a good attorney can be. Any attorney worth his or her bar card would have shut this down immediately. Like
assuming that the client's listening, because he
yes,
could have just not listened to the attorney's advice as well.
That's true, but essentially, if you're going to have someone who's entered into a proffer and speak about an investigation, usually clients will ask for some type of letter from the agency saying you can say this, you can do this. There's certain, leisures given. It is the fact pattern that we've all gleaned, because he, in fact, he had court this past Wednesday, right? Mm-hmm. And at the court, he was arraigned, or he actually delayed the arraignment, meaning Mr. Davis, and so now he'll have that in a few weeks. And the procedural posture matters is he's being arrested. He's been arrested. He's not held on bond. And these are oftentimes, more often than not, criminal defendants will actually say things on jailhouse calls and things like that to further implicate himself. But what's really interesting about this case, for your listeners and viewers, is that they known about his confession and have been letting him, according to the district attorney who came out to speak today and the sheriff on Friday, they were kind of laying this trap for him that he just couldn't help himself. Okay. They keep talking about it over and over again. So now, if Mr. Davis has this reputation of being boastful, like he was the best drug dealer LA's ever had,
it's funny. It's funny how people like to brag about that kind of stuff, but you're absolutely right. I mean that.
Right. So in our world, and sometimes we all know this, language can fail us.
Right.
But now, if you have someone who not once, not twice, but 5 or 6 times has given a play-by-play of how Tupac Shakur was murdered, and saying that he didn't pull the trigger, but he gave the order for someone to do it. And here's the other thing too: he was the driver of a car that had 3 passengers in it. Okay. All other people, the 3 passengers who were in it, have passed away. The only other person who's a witness to the case is the driver of the car that Tupac was in, who's now also in prison for 27 years for drug trafficking. He's not what we would call an ideal or credible witness.
Right.
But he is, and he was the head of, I think it was Death Row Records. He has refused over and over again to give any names about it, because all of these people knew each other.
Right. And I believe that's Suge Knight that you're referring to.
Right.
Yeah. And he's been in and out of prison since this happened. And I'm sure, being in prison, if he is known as a rat, that could result in certain things from other inmates that he may not want. But, going back to the immunity thing, I mean, so, you said they kind of laid a trap for him here to just kind of incriminate himself with his own words. Obviously, somebody must have given him the idea that he had immunity, but like you said, unless it's in writing, it doesn't really seem to count. Is that correct?
Right. And you typically, in a proffer or some type of immunity or interview, you would actually have, it looks like a contract.
Okay.
That the state or the prosecuting entity or the feds, whoever it is, they would agree to, within the terms of this investigation, that nothing could be used against you. Now, there's a caveat to that in general. If someone were to testify, even if you're given immunity, and then, because when you do a proffer, you're under oath. And that creates the idea that you could perjure yourself and things like that. Oftentimes, though, in immunity deals, if that person were to testify or in another legal proceeding, they say something contrary to what was said in the actual immunity deal or interview, it then can be breached for that reason. You could be charged with perjury.
So basically, if you're not honest in the proffer, if you say something, if you say one thing in the proffer and then go testify to something completely different, then they can still bring charges against you.
Right.
Gotcha.
And so that kind of sets up the idea, though, that like government entities use this tool very often for complex cases or more serious cases, foregoing smaller crimes to go after more serious people. But in this case, obviously, you have a case that's been unsolved for so long. It's one of the most notorious unknown cases in the modern century, right?
Right.
And you had someone who couldn't help themselves. And I think that obviously this case is in its early procedural posture. And if your viewers or listeners, meaning, when you are arrested, you have an absolute right to remain silent, and you have an absolute right, meaning you're presumed innocent until proven guilty. So he is innocent, I mean, in terms of the eyes of the law. But he hasn't even been arraigned yet, meaning he doesn't even have a lawyer yet. So it's really early on in the process. But if you have 5 or 6 interviews where you give essentially a full description of what happened, it's going to be really hard. So even if he did have real immunity during that proffer originally, because he's talked about it outside of it, it's almost irrelevant. It almost doesn't even matter.
Well, let's talk about that more when we come back. We have to go to break real quick. You are listening to the DeWitt Law Review on 107.3 FM, AM 580, WDBO. We'll see you after the break.
The statute of limitations in Florida for filing a personal injury lawsuit is now 2 years, which means you have a very limited window to bring a claim. So if you're in an accident, you don't want to wait. Cases do not get better with age. You want to contact an attorney right away and start that process.
Welcome back to the DeWitt Law Review right here on 107.3 FM, AM 580. I am attorney Mo DeWitt. If you'd like to join the show, give us a call, 407-536-6737. We're always here to answer your legal questions on Sunday mornings, or you can email us, ask@dewittlaw.com. But we do have a very special guest with us discussing some breaking legal news that's been out there. Jacob Stuart, again, thank you for joining us. Jake is a criminal defense attorney. And Jake, if people want to get a hold of you, if they are facing criminal charges or have some legal questions, how can they get a hold of you?
They can call my cell phone at 407-416-5987 or our office line that responds 24/7, 407-545-6416. Or they could just Google Jacob Stuart Law and it'll pop up.
Perfect. Yeah, so if you do need any help, with criminal defense, I think you do all sorts of criminal defense stuff.
We help people and companies, whether it's crisis management, government investigations. That either can be civil or criminal. But I've tried over 130 jury trials, most of those being criminal.
Yeah.
And I'm very proud of our record and what we've done here in the past 13 years in Central Florida.
Well, again, I really appreciate you joining us because I know you have in-depth and personal knowledge to how these serious cases work, especially when it comes to these proffers. And one of the things you were saying right before we went to break is, if a defendant, and if you're just joining us, we're discussing the arrest in the murder case of Tupac Shakur. And, in this case, the suspect here who's now been arrested, the defendant, he had a proffer with a law enforcement agency, and he somehow believed that he had immunity, went out, wrote a book, did interviews for Netflix documentaries, and now obviously they're using his own words against him to basically arrest him and ultimately try him for this murder. But one of the things you were saying before we went to break is that if you start talking in the media, talking in the public about what was said in the proffer, that may actually be a way to void the proffer. Is that right?
Well, right. Or in the alternative, it makes what's said in the proffer irrelevant because you're already saying now outside of the proffer. Remember, you got to think of the proffer. It's almost like a bottle of water, right?
Okay.
And if you pour the water in there and you put the lid on it, the water can't get out. But if you pour water now on top of the bottle when the bottle has been sealed, it can't go back in there. It's a very kind of give you an idea of like the content of what you're saying can't be sealed in at this point. And then on the flip side, I think I wanted to give an example. So like, let's say that in this case, Mr. Davis, Dwayne Keefty Davis, who gave a proffer, and it's been confirmed now by the relevant district attorney and investigating people out in Las Vegas, the sheriff out there, that he's been on their radar since 2008, 2009 when he gave this proffer, unrelated case. And they basically, once they found out that he was going to do this documentary series on Netflix, wanted him to basically almost dig his own grave.
Okay.
And to give you an idea, he actually, gave a whole description of the murder and then came out and actually said, here's a quote from his memoir. I'm one of the only living eyewitnesses to Tupac's killing who also knows the much larger story around the reasons of why Tupac and Biggie were killed. I was considered a prime suspect in both the Biggie and Tupac killings for years. I'm the real story. Then jumping on them, meaning Tupac, jumping on my nephew, gave us the ultimate green light to do something, he said in his memoir. Tupac chose to play the wrong game. He goes on to talk about, many things. And actually, again, the prime state attorney in the case, district attorney, said that his memoir really reinvigorated, put spirit back in the case. And so even if what he's saying he thought he had immunity for in the actual interview, just like the bottle of water example, the bottle of water now has been opened. I mean, he's now outside of the confines of that. And I think that he just was misguided. And human nature is a really strange thing sometimes. One strand or one piece of, string in the cloth of life per se, if you just pull it, it can unravel. I know that's an analogy that I've known since a little boy, but in this case, it's almost like the pride before the fall. I mean, he's so prideful now, and he was so confident, and whether a lawyer misadvised him or he went against his lawyer's advice, what he did is built the case against him that otherwise they couldn't prove. Because like we talked about in our prior segment, there are no other witnesses who are alive for this case.
Right. He's the last remaining witness. I want to talk to you more about that, but we do have to go to another quick break here. We'll be right back. This is the DeWitt Law Review on 107.3 FM and AM 580 WDBO.
Story time. So I want to tell you a little story about a call I got about a year ago.
This guy gave me a call. He was just in a car accident. And I talked to him for a while. I told him what to do. Told him he needed to go seek medical treatment and get checked out. He said, thank you. I appreciate your time, but I'm not going to hire you. So not a problem. If you have any questions, concerns, let me know. Happy to talk to you anytime. About 2 weeks later, I was actually in the Bahamas. About 2 weeks later, he called me back and he goes, spoke to the insurance company. They're offering me $770 and they're saying I'm 30% at fault for the accident. You're hired. Sent him the paperwork, got him signed up. That was about a year ago. Today, we just settled his case for $100,000. The insurance company wanted to pay him $770 to resolve that claim. And this is just a prime example as why you should never settle with the insurance company that soon after an accident. You don't know what your injuries are. You haven't gotten checked out by a doctor. You don't know if you're going to need surgery or if there's a tear in a ligament or something more substantial. So when the insurance company offers you quick money after an accident, typically they're offering you pennies on the dollar to go away. And the last thing they want you to do is to hire an attorney because they don't want to pay you the fair compensation that you deserve. Welcome back to the DeWitt Law Review right here on 107.3 FM and AM 580 WDBO. I'm attorney Moses DeWitt, joining you every Sunday at 10 a.m. right here on the DeWitt Law Review. Again, if you'd like to join the show, give us a call, 407-536-6737, or you can always email your questions to ask@DeWitt Law. Additionally, if you'd like to contact the office or have any legal needs or something we can help you with, we are available 24 hours a day at 1-800-DeWitt-LAW. That's 1-800-339-4885. Or you can always learn more about the firm at DeWittLaw.com. But back to the show this morning, we have a very special guest joining us. Attorney Jacob Stuart is here discussing with us the arrest in the murder case of Tupac Shakur, a murder that occurred 23 years ago. Has a lot of intricacies in it, and a lot of kind of unique things for a murder case. And so we'll jump back into that conversation. But Jake, again, I just want to let people know how they can reach you if they need to get a hold of you.
Just like the DeWitt Law Firm, we're available 24 hours a day, 7 days a week at 407-545-6416, or they can Google me at Jacob Stuart Law, and they can get all my information that way. But thank you, Moses.
Yeah, absolutely. And thank you again for being here. We were discussing before we went to break, how this whole immunity thing worked, because in this case here, if you're just joining us, the person who was arrested in Tupac's murder believed, or at least it appears that he believed he had immunity in this case because he did a proffer relating to drug charges. And in that proffer, he mentioned or went into details about the murder of Tupac Shakur. But, we were talking a little bit during the commercial break there. If somebody gives a proffer, and let's say they actually do have immunity in the proffer, and like you said before, that needs to be in writing in a contract
right.
between, I guess, would it be the investigative agency or the prosecutor?
Right. It depends. Sometimes investigative agencies can get their general counsel to negotiate that, or it's the district attorney or state attorney, depending on the jurisdiction or federal authority.
And I would imagine that, as a suspect or anyone involved in those kinds of proceedings, it'd be very important to have an attorney who's familiar with these kinds of agreements and make sure it's negotiated properly. Because I would imagine, like in this case, unless it says it in the agreement, it's not binding. Right?
Right, that's correct. And it's another example of why having a great lawyer or an experienced lawyer really matters, especially when you're dealing with something that could be a life-altering consequence, like being charged with murder.
Right.
And so, but going back to, like you said, like in case you're just joining us, a proffer is an investigatory tool used by government agencies to help figure out cases where they've hit dead ends sometimes in evidence. And oftentimes they're used in white-collar crime cases. They're used in drug cases or used in murder cases where there's some type of dead end in the evidence or stale evidence. And in this case, what we've learned is that Davis, a self-proclaimed drug lord in a rival gang to Tupac Shakur, who was investigated almost 10 years later, right? Mm-hmm. And during that interview, he actually started bragging to law enforcement during an immunity deal about what he did, and that how he gave an order to have Tupac killed outside the MGM Grand after a Mike Tyson fight. And why that's important is that we now have from the district attorney and the sheriff now coming out saying that since he was put on our radar back in 2008 and 2009, we've been letting him just continue to say publicly what he's done and waiting for him. Because obviously for our listeners and our viewers, wherever platform you're listening to us or watching us on, that murder is one of the only charges across the country that routinely, every state's a little different, but I believe every single state has no statute of limitations on murder. And what that means is that for your entire natural life, if you committed that crime, you can still be charged with it. So cases like petty theft, like in Florida,
Right.
it's a year or 18 months. So it's usually some type of structured based upon the seriousness of the crime.
Mm-hmm.
So I can't imagine he had a lawyer advise him what he did. Or like we talked about before, he may have had, a lawyer advise him and he said, you know what, I don't care. Because what we've learned from the evidence at this point is that Mr. Davis was very confident in his abilities and himself. And, sometimes, the pride before the fall is that one of the virtues that a lot of people put in his position have.
Well, he's gotten away with this for 23 years now. He probably thought that, he got off scot-free and, was never going to be caught. And obviously he must have thought that if he was out there writing books to make money off the murder, giving interviews to Netflix documentaries. So it's pretty brazen overall, that he would. I mean, he must have really believed that he had immunity and just not understood how this works.
Well, and unfortunately, it's a beautiful phrase: "Ignorance of the law is not a defense."
That's true. Yeah.
So even if he believed that, and even if a reasonable person believed that, the law does not accept that. And so, obviously, this case we could argue could end up being one of the biggest murder trials in America's history.
It will certainly be, very well publicized, I would think, and very well watched.
And I think it too. I think for millennials, like who are now the largest demographic in America, more than baby boomers. This happened right when we were all in middle school and in high school, right? And this was obviously pre-social media.
Yep.
But it's like we all remember this happening and the mystery behind it. And now you had Mr. Davis in his interviews also bragging about the fact that he may have been involved in the murder of Biggie Smalls, who also was another rapper at the time who was killed within 6 months of Tupac Shakur as well. So I think this case is going to morph into something. I mean, we talked about it off air. It's really early in its procedural posture, so it's hard to tell where it's going to go at this point. But he's in a world of hurt right now, and he's sitting in a jail out in Nevada.
Yeah, it'll be interesting to see, as this case progresses, what kind of evidence they actually have, because presumably they don't really have much forensic or physical evidence. Otherwise, they would have used that to make an arrest a long time ago.
Right.
And they certainly probably don't have a lot of physical evidence tying this individual, Mr. Davis, to the crime, or they would have arrested him. Now, maybe they have evidence tying the other 3 people in the vehicle to the crime, but those people have all passed away since this happened.
Right. So if the state has now come out and saying in the press conferences that they've had by the time we've talked, and as we're talking, is that they believe they not only have evidence to prove beyond a reasonable doubt that he committed this murder, but they actually think they have enough evidence to hold him in jail until the trial. So Nevada, doing a little preliminary research again, I'm not licensed in Nevada.
Right.
But Nevada, upon review, has a very similar bond statute like Florida, where in Florida we have a constitutional right. If you're arrested, you have a constitutional right to bond unless the state can prove to a higher standard of proof, it's called proof evident or presumption great, you committed the crime. And usually for them to do that, they have to have some physical evidence, DNA, fingerprints, recording, eyewitness, and usually also a confession. I mean, the judge has to be more sure that you did what they're alleging you did than a jury does to have to convict you, right?
Because the jury's beyond a reasonable doubt. This is actually a higher standard.
It's a higher standard. It's exceedingly hard to prove. So for them to say that and for them to articulate in court and in the court of public opinion that they think they actually have more than that, it really makes you think they lock in. I think, and I think this is an example for your viewers and listeners to understand that sometimes law enforcement, while far from perfect, this is an example, in my opinion, of taking your time to get something right. Because oftentimes law enforcement rushes into investigations, and I don't know all the details.
Well,
of
it's sometimes due to public pressure, right? People want, a crime happens, people want somebody, a face to, to prosecute, to put the blame on, and they want that to happen quickly, but as we've seen, maybe not necessarily in this case, but other cases, to build a proper case takes time. And I think that's often times why, in federal court, they kind of do the full investigation before they bring charges a lot of times, right?
Yeah, and federal court, I mean, they're ready to roll. I mean, it's not like in state court. I often compare federal court to state court in general. State court's like, one of those tent revivals, like from, 1900s, where like, it's like going to federal courts, like going to a high holy mass or high synagogues for like the high holy days. I mean, it's that kind of difference in terms of the things. But you're right. In general, if the feds are bringing charges against you, meaning the Department of Justice, a U.S. attorney, the case has already been made.
Right.
And that's why they have routinely a 94 to 95% conviction rate at trial. It's very different. But I think in this particular situation, though, Mr. Davis, he's currently sitting in jail. He waived his right to arraignment. It's been set off to October 17th.
Okay.
We're not sure who his lawyer is going to be. If it's going to be, who knows. But you would sure think that, lawyers have to be careful in cases like this, because when I was younger in my career, sometimes you get this allurement of being involved in a big case. And big cases are great, right? Because you can make your reputation, things like that.
Right.
But also, the district attorney, from my experiences in these types of cases with this type of understood political and public pressure, that unless they're completely incompetent, they're going to have all their ducks in a row to a certain extent. And that's why they've weighted this. I mean, they've known about him as the prime suspect, Mr. Davis, since 2008, 2009. So that's 14 years, right?
And they raided his home or searched his home with a search warrant back in July
Of this year, right.
So they've waited several months since then to even bring charges. So presumably, given that this is an old case, it's a cold case. You're right. I would think that they're putting all their ducks in a row to make sure that they're prepared to get a conviction at trial here.
Right.
I mean, that's what it really seems like. One thing you mentioned, and we've talked about this here on the show before, is that, in Florida, like in Nevada, you have a constitutional right to bond. And I don't think that's something that's talked about very often, because a lot of times people see that, somebody's charged with a crime and then they are released on bond, and people get very upset about that. But can you talk about what that means when we have a constitutional right to bond in Florida?
So it's understood that the idea is you're innocent until proven guilty.
Right.
By either your own admission of guilt, or if a jury finds you guilty beyond a reasonable doubt. You want to have the right to pretrial detention, because the idea is if the government can just bring charges and have you arrested, and you don't have a right to be out, essentially you're being deprived liberty before you have the ability to have a jury trial. So it's a fundamental right in the United States Constitution. Florida's taken a next step and followed a lot of states like what Nevada's done, or Nevada's followed Florida in terms of its language. But it allows people to be free and to actually enjoy the presumption of innocence. Now, while out on bond, if you violate it, meaning you get another arrest, or you violate a specific condition, like oftentimes there'll be curfews on bonds, or who you can talk to or where you can go.
Can't go near the victims, things like that.
Yeah, if you violate that, then you can lose it. And then you can lose your right to have a bond. Or like we talked about with this high standard proof evident presumption, great. But going back to this as an idea for Mr. Davis, if I was his lawyer, just from the evidence I know, is he has to be very careful while in jail. There is a high probability when people get arrested, they call their wife thinking they have immunity from the spousal immunity, or someone on a jail call, and they will start talking about the case, further hurting themselves. One of my earliest cases I was actually a young public defender back 12 years ago. My first murder case, and I'll never forget it. We had an incredible case, self-defense, and my client was so excited after meeting with me, not because I was a great attorney, but because he thought we had such a good defense. He went and called and told his girlfriend about his conversation with me and about what we were going to do. He told the state our entire case.
Right, which two aspects to that. Number one, everything you talk about with your attorney is protected by attorney-client privilege.
Right.
So he breached that privilege and basically gave them the right to know your strategy and your conversation.
Right.
But also, in criminal cases, anytime the defendant uses the jailhouse phone, it's recorded.
Right. And so naturally, though, you would think if you were in a government facility and you're in jail, you would be careful what you say. But the psychology of it is that you're in this place, and all you want to do is talk about why you're in this place and why you should get out of this place. And so governments now have not only phones in most jails, but you can text message and email. Mm-hmm. So we're creating now, I tell them, if a client signs me up, or I'm retained, and they happen to be in jail, which is not as often as it used to be. One of my policies is in our agreement for representation is that they will not talk on the phone to family, as hard as it is. They will not email. They will not text. They just won't, because because very often the instinct is immediately is to go call your family to talk about the case. And so, Mr. Davis, if you're listening out in Las Vegas, you got to be really careful. They've already said they have 6 confessions of you, or 6, recordings or statements of you. Create a 7th or 8th is that. And like you mentioned, even if you talk to your attorney on recorded lines, right, there is the privilege, but doesn't mean that someone can't listen, though.
Absolutely. And I mean, I know, I've watched, and one jumps out at me. I watched observing a DUI trial one day. Again, this was probably 10, 12 years ago. And it was exactly that. The person was arrested. They went to the jail. First thing they did, called their mom and said, "Mom, I'm so sorry. We were out at the bar partying. I had 8 shots of this."
Right.
Drove off the road, got arrested for a DUI. And what did the prosecutor do in that case? They, of course, played that tape to the jury, which, is very powerful evidence, because it is an admission of what you did that night. So it makes any defense, very difficult, obviously.
Right. And I think a lot of times, too, people say, well, good riddance, or that's kind of your own fault for doing that. But I think it's important to remember, I think that people very often, when they're in jail, there's something else usually going on. Now, this Mr. Davis, from all intents and purposes, he appears to be a sociopath who
Appears to be a bad guy.
Appears about drug dealer, killing people. But I would say more often than not, if you're in the criminal justice system, there's a mental health, drug, alcohol, or some combination of their addiction. And so we're not to get political on a tangent, but we're almost using our jails sometimes as a stopgap to mental health issue going on in the country.
Right.
And so that's a little bit different. But for cases like this, I would often say is that for very serious cases, I mean, for your listeners and viewers, if you're meeting with a government official and you have the resources, if you're not going to hire me, hire any lawyer. Any lawyer is better than no lawyer. You should never, because I have represented so many companies, and I've represented Fortune 500 companies to a mom and pop stores, everything in between. They think they're doing the right thing. They have nothing to hide. And the government's looking to jam you up.
Right. Now, I've seen that many times, too. And I want to talk about that some more. It's a great point. But we do have to take a quick break here. This is a DeWitt Law Review on AM 580 WDBO and 107.3 FM. We'll be right back.
When it comes to any accident case, the biggest thing that the insurance company is going to look at to value the claim, to value the case, is your medical records, because that's what documents the injuries related to the accident, which is why when you go to the doctor, you need to tell them everything that you believe is wrong with you, everywhere it hurts. Even if you think maybe it's not that serious, it could turn out to be serious later on. I've had cases before where a person just had some shoulder pain, they didn't think it was a big deal, but it turned out to be a torn ligament that required surgery. So these are the things you need to be telling your doctor so that they can document it in your medical records. And it's better for them to be overly cautious and overly thorough in their examination to make sure there's nothing wrong with you than to miss something, and a year or 2 years down the road, you have a significant health issue because you didn't disclose that to your doctor at the time.
Welcome back to the DeWitt Law Review right here on 107.3 FM and AM 580 WDBO. I am attorney Moses DeWitt, and I am joined this Sunday by attorney Jacob Stuart, and we have been discussing the arrest and the murder of Tupac Shakur. But I wanted to talk about, your point that we brought up right before break, Jake, was a great one, and that's anytime you're dealing with the government, even if you have great intentions, you should really have an attorney advising you. And can you expand upon that a little bit for us?
Right. So, I've represented large corporations to mom and pop stores to, when I was back, 12 years ago, I was a public defender representing people who couldn't afford a lawyer. So I've had a real spectrum of different types of clients. And in general, it's not a coincidence, like, whether you're Donald Trump, Hillary Clinton, Peyton Manning, when you're under investigation, to have a team of lawyers if you can afford it.
Right.
Because it allows you different experiences and different perspectives. But for the general population, having a lawyer present when dealing with the government is the right thing to do. One, usually they've had interactions with the past. And two, it limits what they can and can't say and how they can do that. But, I have an example that involves it was my first case ever in the media. It's 12 years ago. And for Orlando listeners, 12 years ago, it was in the news that someone allegedly, and I say that allegedly because the case was ultimately dismissed, went into Lake Eola one night and stole one of our swans. Now, I learned during that time that these swans, I thought, even I'm a 5th generation Floridian, grown up in Orlando all my life, I thought the swans were indigenous. And actually, they're from Australia,
right?
And they've been shipped in, and they all have microchips in them. I didn't know that until all of this. And so my client thought he was a homeless person at the time, and he's given me permission to talk about this, so it's all right. I'm not breaking attorney-client privilege. He actually had intent to eat it.
Oh wow!
Right.
I didn't know that. But I remember the story because we used to call this the swan strangler.
Right.
Yeah.
And he had intent to eat it, and he thought it was a wild animal and was
right.
city property, and you have a right to, if you need it,
Well, and people do that with like iguanas in South Florida. So
do they?
Yeah, I mean, people. I've seen homeless
Iguana
people.
chili?
Yeah, and people they use it. They say it tastes like chicken. I don't know, but yeah, I mean, it may be the same mentality.
So he didn't get to that point. There's an OPD even 12 years ago has a large presence in downtown Orlando,
right.
and they ended up arresting him before. No swans were hurt in this case, just so the viewers.
It's good to know.
Right.
Yeah.
And the swan in question, actually, his name was Ruffles, and he was a beautiful black swan. I think he's since his passed, but he was fine. I bring this back though because this case was in the public eye, and the state got a hold of calls he made while in custody to his family, where he started talking about the fact of what he was doing, and he thought he could do it and all these things, and it made the state's case for him. I mean, the state already had eyewitnesses,
right.
but you had a confession now, so it was just another reminder that you have to be careful. And by the way, that story kind of dovetailing, he tried to explain to the police what he was doing, thinking
right.
he could say, "Listen, I am desperate." And he really was desperate. He was down on his luck, and he was truly hungry.
Yeah.
And that happened. And this is all in the public and all those things. But it's an example, though, that one, don't make calls talking to people about what you've been charged with on a recorded line. And two, if the police stop you, it's usually not in a good situation to talk to them and try to explain your way out of it, because most cases that lawyers get involved in can be overcome if there's circumstantial evidence, but for confession or but for misstep. And so even, it's human nature, right? When we tell the same story over and over again, for there to be nuances and difference, right?
Right.
You could actually argue that if you tell the story the exact same way every time, it's almost like you memorize it, like to overcome the idea of a lie, right?
Yeah.
So, but law enforcement, though, they're trained to look for these nuances and differences to try to jam you up, especially the federal agents. You can actually be charged for giving a misstatement or a lie, even if not under oath, to a federal agent. So
right.
It's just another example to be careful about when dealing with the government. Not trying to be anti-government or conspiracy.
No, I mean, it's a very, because I think, like you said, human nature, you want to explain it because you're trying to explain that, hey, I haven't done anything wrong. And usually, they're using your explanation where you're trying to get out of trouble directly against you. You're building their case for them. But, I mean, we are out of time for today. But, Jake, thank you so much for going on the show today. It's been a fantastic show. I hope you'll come back again sometime soon, because I think we could probably talk for hours on end about this stuff. But this is the DeWitt Law Review right here on AM 580 and 107.3 FM WDBO. We will see you next week right here, Sunday at 10 a.m. Have a great weekend.